Imagine you've just splashed out on a shiny new laptop. You get it home, plug it in, and a few hours later, disaster. It sparks, catches fire, and leaves a huge burn mark on your desk. Now, you're okay, thankfully, but your property is ruined. So who's responsible? Who pays for the desk? Is it the shop, the company that made it, or is it just bad luck? Well, this exact kind of problem is what product liability law is all about.
This video was created with AI to support SQE1 study. We are independent and have no affiliation with the SRA, Kaplan, or the SQE. We do not share exam content, and our videos are for informational purposes only and should not be used as legal advice. Please check and refer to primary legal sources and recommended prep guides as you study.
All right, let's jump right into a really key topic for your SQE1 exam, product liability. Now, I know it can seem a bit complicated, but trust me, we're going to break it all down. By the end of this, you'll have exactly what you need to tackle those exam questions with confidence. So let's get into it.
So here's the game plan. We'll start with the absolute basics. Then we'll look at the two main ways you can bring a claim, the common law route and the Consumer Protection Act. After that, we'll figure out who you can actually sue, what defenses they might have, and then we'll wrap it all up with a super handy revision checklist to get you exam ready.
Okay, let's get stuck in. At its heart, product liability law is pretty simple. It gives you a way to get compensation when you've been harmed by a faulty product. The tricky part is that there are two different legal paths you can take to do this. Think of it like two different doors to get to the same place, and knowing which one to open is absolutely crucial for the SQE. Now this is the whole topic in a nutshell, so really pay attention. On the left, we've got negligence. This is all about proving the producer was at fault. You have to prove they did something wrong, that they were careless. It's a high bar. On the right, we have the Consumer Protection Act, or the CPA. This isn't about fault at all. It's about whether the product had a defect. This is what we call strict liability, and it's much, much easier for a claimant to prove. Let's start with that first route, the traditional one, negligence. Before the CPA came along in 1987, this was pretty much your only option. And the whole case hinges on the manufacturer's actions. Did they mess up? Were they careless? As you can imagine, proving that can be really tough, but it's still a valid route you need to know for the exam. To succeed in negligence, you have to prove four things, four hurdles to clear. 1, that a duty of care was owed. That's usually the easy part between a maker and a user. 2, that the duty was breached. This is the killer. How on earth do you prove what went wrong on a factory floor you've never even seen? 3, you have to show that specific breach caused your damage. And 4, the damage itself had to be foreseeable. If you fail on any one of these, your whole claim falls apart. And here's a neat little concept, the learned intermediary doctrine. Think about prescription medicine. A drug company could argue, look, we gave the doctor, the learned intermediary, all the complex safety warnings. It was their job to explain it to the patient. It's basically a way for them to say they've done their bit and pass the responsibility down the line. Now, because proving negligence is so incredibly difficult for the average person, Parliament stepped in and created the Consumer Protection Act in 1987. And honestly, this was a total game changer. It basically said, forget about trying to prove who is careless. Let's just focus on the product itself. This shift to strict liability made it so much easier for consumers to get justice.
So, under the CPA, everything hangs on this single word, defect. So what is it? Well, the Act says a product is defective if its safety isn't what people are generally entitled to expect. And that wording is key. It's not about what you personally expected, it's an objective test. It's about what society as a whole thinks is a reasonable level of safety, taking everything into account from the adverts to the warnings on the box. The big case that explains this is Guy B. Dupuy. This involved patients who received hip implants that were failing at a really high rate. The court had to figure out what the entitled expectation of safety was for an implant. The key principle that came out of it was this. You judge the product based on the knowledge that was available at the time it was sold. You can't use the benefit of hindsight and say, well, we know now that it's dangerous. The question is, was it safe based on what was known back then? Imagine a new phone comes out in 2024. It passes every single safety standard that exists. Perfect. But then, in 2025, we discover there's a rare battery flaw that makes it a fire risk. Now, even though the company followed all the rules, a court could still say the phone was defective. Why? Because the public is generally entitled to expect that their brand new phone won't just catch fire, regardless of what the official standards said at the time. See how that works? Okay, so you know the product's defective and you know it's caused you some harm. The next question is a pretty important one. Who do you send the bill to? Who do you actually sue? The good news is the CPA is really clear about this and gives us a nice, simple hierarchy. Think of it like a chain of command. Your number one target is always the producer, the company that actually made the thing. Also in that top tier are own branders, like a supermarket that puts its own name on a product, and anyone who imported the product into the UK. You only go after the supplier, the shop you bought it from, as a last resort. And even then, they have an escape route. If you ask them who made it and they tell you within a reasonable time, they're off the hook. So we've said the CPA uses strict liability, but that doesn't mean it's absolute liability. A defendant isn't automatically guilty. The Act gives them a few specific, clearly defined defenses they can use to try and get out of it.
Now, you've got a few options here. They could argue they were just following the law, or maybe that you contributed to your own injury. But the big one, the one you really need to know for the exam, is the development risks defense. This is where a producer says, look, at the time we made this, the state of scientific knowledge was such that nobody in the world could have known this defect existed. It's an incredibly high hurdle for them to clear, but it's a vital defense to understand. Right, that's all the theory covered. Now it's time to put it into practice. Let's switch into full-on revision mode and test what we've learned with some exam-style questions. Okay, first question. A faulty hairdryer burns your favorite rug. The rug is worth £250. Can you claim for the cost of the rug under the CPA? Take a moment to think about it. A, B, C, or D? And the answer is B. While the CPA does cover damage to private property, Section 5, subsection 4 says that the claim has to be for more than £275. Our rug was only worth £250, so that part of the claim fails. All right, next up. A company makes a dodgy gear mechanism for a bike. Another company builds that gear into a bicycle. The bike is sold, the gear fails, and a rider gets hurt. Who's on the hook under the CPA? The correct answer here is C. Both of them are liable. The law says the producer of the final product, so the bike company, and the producer of the faulty component part, the gear company, can both be held responsible. This is called joint and several liability, which just means the injured cyclist can choose to sue one, the other, or both of them together to get their compensation. It gives the claimant the most options. So let's do a super quick recap. First, get this burned into your brain. Negligence is about fault. The CPA is about a defect. Second, the key case for defining a defect is G v. Dupuy. Third, remember that liability chain, producer first, then importer, then supplier. And watch out for those common pitfalls, that pesky 275-pound minimum for property damage and the strict 10-year cutoff for any claim. Nail these and you're in great shape. And I'll leave you with this little puzzle to think about. The CPA was written in the 80s for things like toasters and cars. So, how does a court apply that entitled expectation of safety test to something like a self-driving car that learns as it goes, or a smart home device that gets new software every week? What are we entitled to expect from a product that is designed to change day by day? It's a huge question, and the courts are only just starting to figure it out. Thanks for joining me today.